The third part of the analysis is called the character of the governmental action. In the analysis of whether a regulatory restriction could be considered a taking, the courts look at the character of the governmental action. There hasn't been a lot of action on this prong of the test. For the most part, the courts have found that the governmental actions in question are a legitimate exercise of the police power of the state. And there's quite a bit of case law that says the protection of the environment is the legitimate exercise of the police power of the state. One case, old case in Maine under the site location of development law called In Re Spring Valley, the court said, we consider it indisputable that the limitation of property for the purpose of preserving from unreasonable destruction the quality of the air, soil, and water for the protection of public health is within the police power. So that's pretty well settled that environmental protection is a legitimate use. So I'm afraid I can't give you easy answers, but that's the law, a little bit about the law as it is now and the way the courts would apply it. It's not clear. The courts have said over and over again this has to be done on a case-by-case basis. But those are the considerations here, and that's the way the Maine case law has been going.
Senator Chairman.
Thank you. Do you have any cases where the landowner actually won?
Well, the big case is Lucas versus South Carolina Coastal Council. That's a U.S. Supreme Court case where a landowner bought some property wanting to build a house on it. It was a sand dune case. And in that case, interestingly enough, the court found that the regulation prohibiting, which resulted in him being prohibited from developing that lot, rendered his property valueless, and it was a complete taking. That's a big case. But then, since then, the courts have danced around it and backed down to some extent. So yes, some people do win these cases.
Are there any cases where there's a process of an accumulative effect? Something happened in 1990, 1995, 2000, and the court will look back and say, X happened in 1990, 1995 you did something else, whether it be a zoning, and then 2009 you're doing something else. And so to look at the accumulation of those restrictions, then...
I'm not familiar with a case like that, but there are thousands of cases, so it's possible one exists somewhere.
This is good from a standpoint of United States and Maine law, but when you throw into the mix multinational corporations, if a multinational corporation decides to put in a charge that there's a violation of Maine or local, county, state, or Maine law, I think then in fact the Fifth Amendment, which may protect us in certain instances, is basically kind of thrown out of the water. The United States Constitution is second to international trade agreements, and that international trade agreements supersede the United States Constitution. I think it's been actually proven on one case that it might be okay in America, but if you're dealing with a multinational corporation or an American corporation here in America that has a subsidiary in Panama who brings a suit, well, then we're dealing with a whole set of things, and that's why this committee was formed, and that's why I know I got really involved, because I mean, like, I don't believe our Fifth Amendment has the three words that scare the hell out of me, which was tantamount to expropriation. I don't think that falls within the jurisdiction of the United States Constitution and stuff, and that's why I think it's important to look at where we're headed from Maine and United States law, but we're also looking at it, will any of these potential laws or municipal regulations, does that present a case where if a multinational corporation decides to follow suit, or if Nestle's or the one in France, if they decide to say, well, I don't agree with that, then you're going to have to go through a different court of rules and regulations.
Would somebody have to demonstrate that the current regulatory scheme is not protective of the environment?
I don't think that's the analysis that the court goes through. The court goes through, is this a legitimate area of undertaking? It's not evaluating under that particular analysis. It's not evaluating, is this adequately protecting the environment? It's just saying, is the character of the regulation or the new law the kind of thing that the government is allowed to do? So it's not judging the merits of, is this enough, is it not enough, okay?
Do we in fact have the right to say, before you make a decision about future takings, before you make a decision about future profits, before you make a decision about the right of an entity, even at the sub-governmental level, to profits and the corporate life, you must, as a matter of course, in the tribunals, review what that environment has been. If an investor is not entitled to a static environment on regulation, can it not equally be argued they're not entitled to a static environment on law and precedent? And therefore, can you not say, we will agree to review by tribunals if the tribunals take into account the law at the time that these transactions occurred? And that's a question not just for you, but for us as a body to look at moving forward.
I don't know, I'm not an expert on trade agreements, so I don't know to what extent you could do that. It would be not something that would be before the courts in this country, you're saying, in those reviews there. Yeah.
The Maine Constitution says that you can't take property unless the public exigencies require it. And I think we can all agree that when many of the environmental regulations were adopted in the 1970s, the public exigencies required it because, you know, rivers were catching on fire. But we have a situation now whereby we have a groundwater resource which is renewable, and the current regulatory, just for sake of discussion, so the current regulatory process really requires, whether it be through DEP or drinking water systems getting approval of the State Drinking Water Act, it's being managed in a sustainable fashion. Would the state have a fairly high standard to meet, given those situations, the changing ownership that would occur, you know, if you went from absolute dominion to reasonable use?
I'm not going to go into the policy question of whether you can make the case for it, but in terms of whether a court would consider it an unconstitutional taking, I don't think the court would. But again, it's very fact-specific, as I said. I mean, the question is it a taking of property? That's where the court would focus. I don't think the court would get hung up on, is the character of the governmental action unacceptable. I think the courts would probably find the character of the governmental action acceptable, even under those circumstances that you outline, because the police powers of the state have been interpreted historically very broadly. So it's not required that there be exigent circumstances just to regulate, but the question is, does the regulation go so far as to be a taking? And that's where the courts struggle and go through these contorted, sometimes, analyses. So it's really fact-specific, but I don't think they would stumble, which I think is your question, would they stumble on saying that because the system is working and there maybe isn't a threat to the environment, is that an unacceptable governmental action? That's your question, right? I don't think they would stumble on that.
So I think what you're saying is the police power is pretty absolute.
It's pretty broad. It's been interpreted pretty broadly by the courts, yes.